My name is Jack Lloyd. I'm a constitutional lawyer specializing largely in cannabis and psychedelics related issues, in particular medical access to these substances. And I also have significant litigation ongoing involving Indigenous rights as they relate to cannabis. Well, certainly the legal logic comes from a case originating in British Columbia, dealing with what amounts to Indigenous rights as expressed off, quote unquote, the reserve. And that's a case called Chilcotin. And ultimately, that was years of litigation, but ultimately the BC Court of Appeal and the Supreme Court of Canada have affirmed that Indigenous rights can and do exist off the reserve. They're not delineated by reserve boundaries. They're delineated by traditional territories upon which those rights were exercised prior to European invasion of North America, or what's sometimes referred to as pre-contact exercising of rights. And so the underlying legal arguments associated with Indigenous cannabis dispensaries operating off reserve is very obviously tied to the exercise of those sui generis rights. And ultimately, it's a legal issue that needs to be determined ultimately by a court, but for which a significant number of Indigenous peoples are asserting those rights off reserve on the basis that their people have been engaging in trade off reserve and on all of their unceded land and traditional territories since time immemorial. So that's the big picture view of the legal argument. There are associated arguments connected to what's sometimes called economic genocide and trade rights that have been previously outlined by appellate courts across Canada. There are two ways of viewing it. One is that cannabis constitutes a trade like any other in which Indigenous peoples may engage. And another focuses on a highly important and technical assessment of the Indigenous relationship with the cannabis plant historically, which is really not reflected in the Indian Act, which is a problem in and of itself. But ultimately, a historical relationship with the plant itself that predates European invasion, and as such, that history has never been placed before the courts and certainly has been largely disregarded by every branch of government, frankly, in a very aggressively myopic way. So that's kind of the slightly tighter view of this sui generis right associated with trade in cannabis and trade in general, in particular with certain psychedelic substances that are known to be deeply connected with certain Indigenous religious rituals. Those are already effectively not prohibited for those purposes. But the broader argument regarding Indigenous health and Indigenous health decision making is very strong. So the legislation governing certainly access to medical cannabis has now been struck down as unconstitutional twice because of a lack of in-person access. And after those two decisions, one in Alberta and the other in Saskatchewan, after those decisions, the federal government never changed the medical cannabis program. And so it's left, and they certainly never consulted with any First Nations peoples about it. And so the argument is quite strong, because when you speak with Indigenous people and Indigenous health experts, they affirm that non-in-person medical advice access is not in line with traditional values held by Indigenous peoples. So the problems that have been outlined with the federal regime in other cases are even worse for Indigenous peoples. Particularly, often telemedicine is touted as a solution for certain remote communities, but my submission is that overregulation for certain issues actually is counterproductive, and in my view amounts to a serious violation of Section 7 of the Charter. Really what the province and the federal government and the municipal government are doing is trying to pass the buck on this issue ultimately. So the feds are saying, look, this fits squarely into the constitutional head of power attributed to the provinces, which is Section 92 sub 13 of the Constitution Act. But my submission is that that's really an unfair characterization, because it's really regulated pursuant to the criminal law power, which is indeed federal. But in any event, the only way that a final determination on this is going to happen is if we get some sort of legislative guidance, which frankly is unlikely, although Health Canada is engaging in a current request for comments from the public. But beyond that, the legislative and executive branches of government are unlikely to proffer any guidance. It's really going to be the judicial branch of government that's going to provide that. So there will be a case, and it remains to be seen. The courts are going to have to provide us with guidance on this, whether by way of a reference, which is always possible, which is basically when we pose a legal question to a judge. But in my view, because there's a charter violation associated with this, it really is better suited for the factual matrix associated with a trial, so that there's an evidentiary foundation for the assertions being made by Indigenous peoples, as well as the Crown. I don't think the Crown is entitled to say that they consulted with First Nations people about any of this. There's been some late attempts to engage in consultation, but it is too little too late. So in my view, that there has been a failure on the government's obligation or duty to consult. And in any event, I think it's unlikely that band councils en masse agree with what most people are asserting in regards to their rights. So there's just a multiple levels of government, federal, provincial, municipal, and band council, all in the mix, with ultimately a court is going to have to give us an answer eventually. So from a regulatory perspective, the cannabis regulations and the Excise Act and various provincial tax acts have resulted in a situation where cannabis is being taxed at an incredibly high rate, and it's resulting in a situation in which it's very, very difficult for licensed retailers and licensed federally licensed producers and processors, et cetera, to engage profitably in the industry. And so certainly you've seen massive devaluations of publicly traded companies, and furthermore, really deep problems at an industry-wide level, in that no one is able to make a profit as a consequence of these regulations. And so it's in that context that a significant number of Indigenous producers and retailers that have existed for many years on reserve are also now in operation, in some instances off reserve, hoping, I assume, to bring a test case for the purposes of challenging these issues. The charter does not necessarily protect economic rights, and in some ways, it may be that that was ultimately the federal government's goal, was to prevent any more findings of unconstitutionality associated with the federal regime. But the argument in relation to this sui generis right held by Indigenous peoples, especially on their traditional lands, which in their submission are not ceded and or certainly not validly ceded, that those arguments are very potent. So from a big picture perspective, the regulated industry is really struggling, and the Indigenous industry is providing in some ways a model for a healthier and more robust cannabis industry, and certainly one that is more in line with the Crown's duty to consult with First Nations people, and the historical guardianship that was supposed to be in place since the Royal Proclamation of 1763 was signed. So I think, in a sense, the failure to consult with First Nations peoples has resulted in First Nations peoples doing it better than the federal government and provincial governments have been able to do. And that's the situation that we're in now. You can just call my office if you want. I'm not a super duper techie person. I don't I have a website, but certainly I'm always happy to represent anyone that's being faced with nasty, prohibitive laws associated with cannabis, or that don't allow an Indigenous person to properly exercise their rights in a fulsome manner. So if anyone wants to speak with me, you can give me a call. My phone number is 647-235-3972.